Everybody, it's Paul Yokobetis from Cary Estate Planning, back with another video as part of our 2020 challenge. And today I wanted to talk about excessive legal documents. I just reviewed a 55-page will. 55 pages. Why? It's way too long. There's way too much involved in it. Talks about things that most people in North Carolina would never even dream of having. It's way overly robust, inclusive, excessive. I'm not sure why. I'm not sure why it was drafted that way. This certain, or this specific client, probably 3/4 of the will didn't apply to them. It's just template, boilerplate language that basically seems like every box was checked on the drafting software. Every single one for every single provision, every carve out, every possibility. Why not, right? The issue with that, though, is it makes it really hard for the fiduciaries to perform under that sort of document because they probably don't know where to begin. They don't know what they can and can't do. So it makes the administration of that type of estate a lot more difficult. And the reason why I was reviewing that will is because the testamentary trustee appointed under that will had no idea what to do. And so they were forced to reach out to a lawyer to figure out what the will meant, how it was supposed to work, what they could and couldn't do, where to start. And if that's something that you're trying to avoid, then brevity ends up being pretty important, not complexity for the sake of complexity. That sort of complexity was probably better reserved for people with much more complex estate issues, much more complex asset holdings, that kind of thing. But that just wasn't needed in this sort of circumstance. So when you're looking at doing planning, it only needs to be as complex as it needs to be, and it should be as simple as possible. 55 pages is a lot.